Good morning, friends. It's Mary. This video is, I'm going to tag my new friend William Bonatati, my new friend Bill from Connecticut. We spoke for a good hour or so last night and swapped eerily similar, if not identical, notes on his experience as a victim of gross judicial misconduct, illegal retaliation by way of police and state attorneys, and of course DEMAS and CVH involvement. This is a Brady motion that I filed on October 26th. Okay. I filed it in addition to my notice of special appearance, motion to dismiss, hand-delivered, by the way, to the court, October 23rd. Again, my motion to dismiss and motion of special appearance, or notice of special appearance. This document, in order to proceed, I first require the court to recognize on record I am responding by special appearance. Okay, this notice or motion I filed as a bill of complaint in equity, presentment to void proceedings and jurisdiction. Okay, several pages to this document, date stamped by the court. Okay, this document, claiming common law jurisdiction, do not consent, blah blah blah, unlawful bills of attainers to violate my state and federal constitutional rights. They don't exist in these courts. We have no rights. Date stamped by the clerk. This is a lawful notification letter and notice of liability. Okay, it also contains the Connecticut Constitution. That the great and essential principles of liberty and free government may be recognized and established. Okay, in the Constitution state, by the way. This I ended up writing, this is one of the most awesomest, if I don't say so myself, writ of habeas corpus. As you can see, I had to handwrite this from prison, where I was sent for 7 weeks, again, pre-conviction, fabricated charges, high bonds. I wrote this November 28th. It was received by the clerk December 10th. I still sat in court. There was no hearing, as this habeas corpus petition requested. I really want to focus on my Brady motion and one specific motion that is not only in this document, but 2 of these others. They say that if you submit something, submit it 3 times. This motion has been in front of Superior Court since 2012, several times by me at Superior Court, and I advanced it to Supreme Court. The Supreme Court in 2013 denied my petition. I advanced it again at appellate level in 2014. The appellate level denied this petition. Attorney Deborah Stevenson, appointed by the court, paid by the judicial branch, filed this motion on appeal. It was denied. And Tony Avalasset, the special, God rest his soul, he dropped dead suddenly a day after I sent him an email a few years ago. I don't think it was a coincidence, folks. He filed this motion in 2012. It was denied. Petitioner moves this court to order a hearing whereby petitioner may present documentary and testimonial evidence to enable this court to make application pursuant to the authority of Section 5447B for an investigatory grand jury into crimes committed by the Torrington government and certain state executive and judicial branch officers involving corruption and unlawful use of physical force and violence to intimidate and coerce the petitioner herein. I've added also the legislative branch and other forms of this motion. Folks, this motion put me on a Connecticut judicial watch list by the judicial branch in 2012 as I had appealed it to the Supreme Court. In Connecticut, if you internet search Connecticut grand jury investigation, you will come to a one-page, very simple old research report by the General Assembly. And it explains that the purpose of Connecticut grand jury investigations, the number one reason to have them is for government corruption. Medicare and Medicaid fraud, that are included since 2010 in my corruption history of indisputable facts to prove this. In Connecticut, the only ones that are allowed by law to apply for a grand jury are the judges and state attorneys. I've actually petitioned the State Attorney Division of Criminal Justice since 2008 with a detailed letter explaining the fraud and corruption, and the Republic Integrity Unit State Attorney Christopher Alexie, headed up by John Whalen, have refused since 2008 through present to do what the Connecticut Division of Criminal Justice is constitutionally required to do, and that is to investigate all crime in Connecticut. I have moved them in hundreds, if not thousands, of emails, phone calls, in-person contact to do their constitutional due diligence, legal and lawful requirements, and they refuse. In 2010, at the slightest false, perjured statement, retaliatory, entrapment accusation against me by police and others, deep state housing authority officials who I was suing since 2006 in documented, actually the housing authority of the city of Torrington since 2003. I began litigation with them to stand up for my rights. And CHRO is supposed to be a law enforcement agency. They don't also enforce anything but their statist, bureaucrat, public employee, bar attorney positions. That's all they do. This is a real huge case. It's a very big problem that we're having here, and I'm not going to continue to allow it to. You see how I always, I never, in all of my established documents in which I establish my status and standing as the living woman, not the all-cap names, and they don't recognize me as anything but a dead vessel. There's $ in my all-cap name. That's all there is by these thugs.